Welcome once again. My name is Yusuf Oluwafemi Salako, popularly known as Ori David. I am a 500 level student of law, University of Lagos, and founder and head of research of the Ori David Consult. So today I want to talk about jurisprudence. The question before us today is, what is jurisprudence? And in attempting to answer this question, this is the outline that we shall be employing. First, we'll be looking at the meaning of jurisprudence. We'll also be looking at the nature of jurisprudence. We'll be looking at the branches of jurisprudence. We'll also be interrogating the question whether jurisprudence is a philosophy or a science of law. We'll also be looking at jurisprudence and legal theory distinguished, and then the utility value of jurisprudence to law students and the legal education, practical evidence of jurisprudence in real life interactions, and finally, we'll be looking at jurisprudence in traditional African societies. And this is the general overview. But for this first part of jurisprudence, we will just be looking at the meaning of jurisprudence and the nature of jurisprudence. And then I ask once again, what is jurisprudence? Now, in attempting to provide an answer to that question, one needs to understand that law as a discipline can be studied from two levels. I would repeat that. Law as a discipline can be studied from two levels. There is the theoretical level and the practical level. You see, when we talk about the practical level, it deals with the study of law in its narrow, specific, and realistic confines, in its realistic and in its limited form. In the practical level of the study of law, we are talking about an instance where every concept of law is studied from the point of view of what the law provides. We want to look at the practical values of law, the functional values of law. We want to look at how law is made, how law is enforced, and otherwise. So when we talk about studying law from the practical value, we are saying that it forms the bulk of what we as law students do in our LLB program. You understand, as law students, we are just concerned with what a term such as an offer. What does an offer mean? What are those cases that have more or less expounded on the meaning of offers? And we want to rely on those cases or these cases as authorities, and that is just all what we are concerned. And we are concerned with trying to discover or to identify whether there is an offer and an acceptance in different transactions. Questions such as, what is the underlying basis of an offer? We really do not ask ourselves. Questions such as, why is it that the law says that where there is an agreement, that agreement must be kept? Is it because the law believes that what it would more or less create trust between what individuals? We are not concerned with why the law says that where there is an agreement and someone commits a breach. Why is it that the law says the person should pay damages, or that the person should suffer one particular shortcoming or the other? We are not concerned with that. And when we look at this, when we talk about what makes a crime, most of us will conclude by saying that, well, a crime is whatever the legislation says is a crime. In fact, some of us, with vaunted pride, we are going to say, well, when we look at section 36, subsection 12 of the 1999 Constitution, it says whatever is a crime is whatever that is written, and then the punishment stated thereof. Most of us would even make reference to section 2 of the Criminal Code to say Criminal Code says any act or omission that is made punishable by law. So when we want to answer the question, what is a crime, we most likely will trace it to a statute, to the substantive law. At this particular level, hardly are we concerned with questions such as whether morality is the basis of crime, or questions such as what are those factors, whether social factors, psychological factors, that impel individuals to commit crime. Or we talk about what is the essence of making an act or omission a crime. What's purpose? What is the objective when we punish a criminal, and then we more or less send the criminal to what? To jail. The question is, why are we doing so? Is it because we believe that it's a tit for tat? No, most times we are not concerned with this whole aspect. So you find it that what students that study law from this practical aspect, they are more or less concerned with what the law says. So meaning that they are concerned with the legalistic view of law, the structural view of law. But like I stated from the very beginning, law can as well be studied from the theoretical aspects. Now you see, when we look at the theoretical aspect of law, it is that aspect of law that most students dread, because it is the aspect of law that you probably cannot see practical evidence. I use the word probably because it is wrong to conclude that when we talk about the theoretical aspect of law, that it does not have functional and practical utility. That is wrong. So many events, so many incidents happen that if we are taking our time to think about them in depth, we would have been able to identify some of the underlying bases, the theoretical values of law. So when we talk about law in a theoretical aspect, it means we are talking about jurisprudence. That is what makes jurisprudence to be a unique cause. And I say it all the time. I say there is no single cause that does not have a jurisprudential basis. There is no single law that does not have a jurisprudential basis. If only we can take time to think, and then we'll be able to identify them. They are there. So, I ask the question once again, what is jurisprudence? Now, in order to begin this exposition, I am forced to also point it out to you that you see the word jurisprudence, or the cause jurisprudence. It is a cause that does not lend itself to definitions easily. So many scholars, different jurists have attempted to define jurisprudence. But one thing you have to understand is that it is very difficult to define jurisprudence. And Adaramola opines that the difficulty in attaching or ascribing a definition to jurisprudence is based on two grounds. First, he says that because jurisprudence is concerned with the study of law, and we know that law in itself is a slippery concept. Law in itself is not a concept that is easily defined. And as a result of that, if jurisprudence studies law, then automatically jurisprudence itself would also not be easily defined. That is the first thing that's the first reason. And the second reason is said that the word jurisprudence in itself is used in two different but parallel sense. But if I may also add to this, it is submitted that jurisprudence does not lend itself to a strict unilateral definition, because it is a cause that deals with law in its abstract, theoretical, and general level, which means that jurisprudence deals more with investigating the content of law as against looking at what law in its structural form. So when you have a statute, and then we can see the wordings of the statute, jurisprudence is not just concerned about the wordings. Jurisprudence is concerned about the unwritten codes, the unwritten values that are inherent in that law. And most times, jurisprudence does not even limit itself to a particular jurisdiction, so to say. Jurisprudence wants to identify, you see, the basis of law, the essence of law. You see, those ultimate truth about law that can be found in every legal system. So jurisprudence is concerned about what makes a law in Nigeria, and then what makes a law in America. And is there any common theme that runs like a thread when you have identified what makes a law in Nigeria and what makes a law in America? This is what jurisprudence is concerned with. But I must also point out that while it is difficult to attach a definition to the word jurisprudence, perhaps the best way to avoid the enormous difficulty that afflicts several definitions of jurisprudence is to look at it from an etymological point of view. So etymologically, when we are talking about jurisprudence is derived from two Latin words, which are juris and prudential, and when added together, it simply means knowledge of law. From this definition, one thing is clear, It is that jurisprudence is a domain of law that seeks to explain to law students, as well as academics, and even legal practitioners and jurists, the unwritten and unnoticeable nature of law. But then, while it is right that jurisprudence, unlike economics, does not have a universally acceptable definition, but it is still of enormous advantages to this discourse that we at least interrogate several definitions that have been adduced by different scholars. At least when we consider some of their definitions, it is possible for us to at least be able to see that common thread, and that we can say that, okay, at the end of the day, this is the notion that these individuals, these scholars, are trying to pass. And that notion would serve as the character of jurisprudence. And with this, the person that would have, the scholar that would have the honor of first mention will be Jeremy Bentham. According to Jeremy Bentham, in his work Christomathia, he said that jurisprudence is the science that corresponds to the art of judicature. He said jurisprudence is the science that corresponds to the art of judicature. But he now said that, but this is not the only sense in which the word jurisprudence is employed. Then in France and in French, it has been used to designate what in English law is called common or unwritten law, in contradistinction to statute or written law. As argued by Jeremy Bentham, the definition of jurisprudence should embrace the notion that jurisprudence synonymizes law and also refers to the theories of law. So to Jeremy Bentham, jurisprudence deals with the substantive aspect of law, and it also deals with the theoretical aspect of law. So when we talk about the substantive aspect of law, it says it deals with the legal culture, it deals with precedents, it deals with the legal system of a particular state. But when we look at the theoretical aspect of it, it says that it deals with explaining the general, artificial, and theoretical nature of law. We see this second aspect of Jeremy Bentham's conceptualization of jurisprudence. It aligns with the Anglo-American tradition that refers to the study of general theoretical questions about the nature of law and legal system. And when we look at when we also take time to interrogate Jeremy Bentham's work, we would see that he classified jurisprudence into two groups. So there is the expository aspect and the sensorial aspect. The expository aspect is where you look at the law as it is. Then the sensorial aspect is where you look at the law as it ought to be. At any rate, other scholars have attempted to define jurisprudence. According to John Austin, the foremost positivist, or should I say the foremost analytical positivist, he defines jurisprudence. He said jurisprudence is the science that is concerned with the expositions of the principles and notions and those distinctions which are common to the system of law in developed societies. So he said the notions and concepts of rights, duties, contract, ownership, crime, thought, etc. So as far as John Austin is concerned, he said that first, jurisprudence is a science. Second is the sense that is only a science that is concerned with explaining those principles of law, notions of law, distinctions, and these distinctions are common to the system of law, in the sense that when a jurist writes about law, jurist is not only concerned about law in his or her own environment. They believe that there are these inherent precepts about law that can be found everywhere. So it is more of something ideal and it can be found everywhere. And this aligns with the natural law school of thought conceptualization of law. You know, the natural lawyers believe that because God has given us a sense of reasoning, and because we all hail from God, and that the law of nature is a law that can be found everywhere, and as a result of that, they try to give us some sort of universal conceptualization of law. They say that whatever is obtainable in Nigeria is obtainable in America, is obtainable in France, is obtainable in Greece, as far as law is concerned. But they are not denying the fact that our social climate, social factors, peculiar circumstances may also inform laws, and that we may have certain differences and all. But they are saying that even with the differences, we will still be able to trace this common feature of law everywhere, anywhere. At any rate, we'll also interrogate what Salmond has also defined jurisprudence. And to him, he said jurisprudence is concerned with identifying those inherent, intrinsic, and fundamental features and contents of law that are available in every legal system. So at the end of the day, that jurisprudence is concerned with those ultimate precepts, the general truth that we can find in every legal system, and that these are exactly what would constitute law, such that when we talk about the rule of law, we all understand what the rule of law is. And they are saying that the rule of law is not the rule of law according to the Americans. The rule of law is not a rule of law according to Nigerians. No, the rule of law is the rule of law wherever you claim to have what? The rule of law. So they are trying to identify what those common features have. That is what jurisprudence is all about. And when you look at this, you see that jurisprudence in itself tries to capture the various angles. When we look at these definitions, you see that they try to capture the various angles of jurisprudence. So at the end of the day, we can all agree that jurisprudence is a theoretical exercise that seeks to investigate the feature of law that is common to all legal systems, as well as the relationship of law with other analogous concepts such as morality, religion, justice, and the social utility of law. Jeremy Hall sees jurisprudence as the search for ultimate conceptions in terms of which all legal knowledge can be significantly expressed. He sees jurisprudence as an investigation embarked upon to identify the ultimate truths, ideals inherent in law, and which can be found universally. You hear that, which can be found universally, thus turning them into those intrinsic features by which laws can be identified and expressed. So you see that they are talking about that jurisprudence is the theory of law, and when we are talking about the theory of law, we are trying to look at the common ground that every law shares. What are those intrinsic and inherent values about law? From the foregoing adumbration and the alchemy of definitions of jurisprudence, it is clear that while the time is not easily receptive to a unified definition, certain features of jurisprudence can be deduced. First is that jurisprudence is theoretical study of law. Second is that jurisprudence seeks to explain the nature of law in a general form in order to provide a deeper understanding of legal reasoning, legal systems, as well as the essence of law in the society. With jurisprudence, one begins to inquire whether a society really needs law. That is the first question. Or whether there are certain circumstances where the law can be thrown aside, and what are those circumstances. Third, we also agree that jurisprudence seeks to provide a deeper and also a foundational understanding of the underlying principles behind the flock of specific laws. So it's not just about the fact that they said, okay, 14 years imprisonment if you involve yourself in same-sex marriage. The question is why? Questions such as, is that necessary? Questions such as, why do we want to prevent two individuals that are not causing harm to other members of the society? Why is it that the law or the state takes it upon itself? Should the state interfere in the individual morality of these two individuals? And what are those circumstances upon which the state would interfere even what individuals are doing do not really constitute harm to other members of the society? Does the state have the jurisdiction? Does the state have the justification? Does the state have the pedestal to also attempt to love a person more than a person loves himself or herself? Why do we more or less criminalize attempted suicide? is it not the person's life? So questions such as these, we begin to speculate, we begin to interrogate. This is what jurisprudence is simply all about. When we sentence a man to and to jail, and then you sentence a man to jail because he got involved in same-sex marriage, or because you believe that what is gay, and then you sentence both of them to jail. Now the question is, what is the reason? What is the basis of providing that punishment? Is it for retribution? Is it to deter others? But then the two individuals that you're sentencing to jail, you understand the very fact that there is a possibility they can still find themselves perhaps in the same in the same place. And you know what that means? The exact thing you claim that you want to prohibit may still flourish even in the correctional center. Or it may even be that perhaps you even separate them, but then you still put them in the midst of certain other gender, and then they get there, and you never can tell the sexual orientation of certain individuals. They will still meet there, and it may still flourish. So jurists, or what jurisprudence is concerned with, is not the fact that we have the law, but we want to start interrogating the essence of law, the functional content of law, and that is what jurisprudence is all about. The fourth feature of jurisprudence is that jurisprudence is an abstract investigation and can sometimes be undertaken simply for intellectual stimulation and academic flourish, without any intent to contribute to any political discourse or whatever. This is what we are saying. There are times jurisprudence may just be an avenue for students to just try and see if their analytical skills are sharpened. So meaning that we just want to engage in some sort of legal gymnastics. We just want to argue. We just want to just talk and want to investigate the law. That is that. Another thing, it suffice to also state that with regard to the last point, jurisprudence and analysis can also be traced and identified in social interactions. But you must understand that regardless of whatever definitions of jurisprudence we align ourselves with, it is clear that certain terms have been attributed to jurisprudence, such as knowledge of law. Some have called jurisprudence to be the grammar of law. Some said jurisprudence is the skill of law. Some said jurisprudence is the philosophy of law. Some said it is the science of law. And some said it is the spirit of law. At any rate, we proceed to interrogate the nature of jurisprudence. According to Merriam-Webster, it said that the word nature means the inherent character or basic constitution of a person or thing. It is the essence of a thing. Merriam-Webster dictionary also defines the word nature to be an inner force, such as instinct, appetite, desire, or the sum of such forces in an individual. Therefore, when we speak of the nature of jurisprudence, we are talking about the essence of jurisprudence. We are talking about the inherent feature, the inherent characteristic, or the basic features of jurisprudence. And to understand the nature of jurisprudence, one would have to also understand the definitions of jurisprudence that have been adduced by different scholars in order to deduce certain features that appear to be the denominator. And with this, we have already interrogated some of these definitions, and by now we should understand what the nature of jurisprudence is. Jurisprudence seeks to speculate about law in its theoretical, in its abstract and general realm. When any event happens or when any event occurs, the jurists are the ones that sit to now try and investigate those unnoticeable, those unwritten, those underlying factors, not just what you can see on the face of it. So that is what jurisprudence is all about. So while you can have two criminal law students, and one is only concerned about, well, the law says that when you have carnal knowledge of a woman, and that is rape and all, and that is, the particular law students will then refer you to certain provisions of the criminal code, or certain provisions of any criminal law of any state. But you can have another student that looks at it, okay, but then the thing is this: why is it that only a man can commit rape? Why is it that a woman cannot commit rape? what is the reason for that dichotomy? Is there any purpose that the drafters of the act seeks to achieve and the likes like that? That other student is thinking from a jurisprudential point of view, and jurisprudence can always be the recipe, can be the desideratum for reformation of law, because with jurisprudence you are able to analyze the law, you are able to critique the law, you are able to attach what we call value judgment to law. And because law is in itself a normative system, and when a system is said to be normative, it means that it prescribes what rules of what conduct, tells us what to do and what not to do. But then the question then is, in what circumstances should law tell us what to do? Why is it that the law is even telling us what to do? Why are you taking the liberty of a man to act the way that he wants? What justifies it? Is that when the Lord takes away that liberty, should the Lord do that all the time? Should a man not decide that he wants to take alcohol as long as he's in his house and he's taking it and is not causing harm to any individual? Should the Lord try to then find a way to say, no, he cannot even take what this? Jurisprudence deals with this aspect of law. So I'm going to end the first part of jurisprudence here for today, but in our subsequent classes we'll also follow the outline where we'll be looking at branches of jurisprudence, and we'll also be interrogating the question whether jurisprudence is a philosophy or science of law. My name is Yusuf Oluwafemi Salako, and I just want to say a big thank you for your time, and I hope that you find this particular class helpful. Do stay again. Thank you.